Let me introduce Isabel Safie, who is a partner here at BB&K, and her practice focuses on employee benefits. Please.
Thank you, Mike. Good afternoon. I think an hour and a half worth of time to focus on pension issues is nowhere near enough time to really cover the topic in depth. And I think that Eric made a very good point earlier this morning, that this is really the start of a conversation to get us thinking about these issues and start working towards finding a solution that is viable. And a earlier conversation made me think and realize that there's no one-size-fits-all solution. That for some of you, the pension issue might be a significant concern related to your agency's viability, but for others, you see opportunities and ways to mitigate those concerns because there might be other resources available that can help offset those costs. And so it's important to realize that it is a multifaceted issue that will require multiple solutions. So in the 15 minutes that I have, I'm just going to cover the current cases that are before the Supreme Court and give you a little bit of background related to that. And the hope that many of us hold out is that we'll get further clarification from the California Supreme Court as to what the California rule really means, because many of us, including myself, have thought that the interpretations of earlier Supreme Court rulings by lower courts have not quite gotten the California rule right, and have created this fallacy or this belief that you can't really change pensions, when in fact the Supreme Court has in the past said that changes can be made if you can demonstrate the need for them, that they're reasonable, and that where the change is more significant, there is a comparable benefit that should be considered. So this is just a really quick representation of headlines that have been that I've seen over the last 30 to 60 days. And all of them are sort of negative headlines about agencies across the state being concerned about the fact that their contribution rates are going to increase over time very significantly. What we don't see are the positive news of agencies being proactive about expected costs and using innovative funding sources, which we'll talk about a little bit more in some of the later panels. So some historical context, the California rule is rooted in both the federal and state constitutional provisions related to the Contracts Clause, that no state actor, being the state or a local government agency, may impair a contract. And so pursuant to that constitutional provision, we have one of the earlier California Supreme Court rulings in Kern versus the city of Long Beach. And Long Beach is a pretty popular player in a lot of these precedent-setting cases, where the Supreme Court held that a right to a pension becomes vested once the employee begins employment with the agency. The question, of course, is what is it? What is vested? And so much of the controversy related to the California rule or the vested rights cases have been related to the substance of that contract. What is it that has been vested? What is it that has been created as a benefit for employees? And so what the courts have generally held is that unilateral changes to benefits that are vested, pension benefits that are vested, can only be made if the change is reasonable and necessary to preserve the integrity of the system, and any negative changes affecting employees should, not must, be accompanied by comparable new advantages. You see this concept addressed significantly in the Marin and Alameda cases that I will touch upon in just a few minutes. But what the court ultimately said is that employees have a right to a substantial or reasonable pension, not a fixed pension. So while a vested right may be created upon the acceptance of employment to a pension benefit, the benefit itself is not yet known, it's not fixed. And of course, there's outside pressures that we see related to pension benefits. And the one that's most pressing, of course, is the increased costs that are being passed on to agencies to fund those benefits. So the first of the cases that I wanted to talk about that came out a few years ago is the Marin Association of Public Employees versus the Marin Retirement Board. And it arises, all of these cases arise as a result of unilateral changes made by a retirement system or the law related to what is perceived to be a vested benefit. In this case, it's a provision of pension reform, AB 340, not PEPRA. PEPRA is an element of AB 340, but in this case, the provision amended the county employees' retirement law. Now, most agencies and CalPERS will think, well, what relevance does this case have to me? And the relevance is that the ultimate determination regarding these cases will affect the way the California rule is applied and interpreted, which affects and applies to any public agency that provides retirement benefits, whether you're in CalPERS, a county system, CalSTRS, or a standalone retirement system provided by your county or your municipality. So in this case, the retirement board made changes pursuant to amendments to Section 31461 of the County Employees Retirement Law that ended the Ventura County decision determination that every item of compensation was included in pensionable or compensation earnable. And in this case, the retirement board concluded that payments such as on-call pay, cash outs of leave, and terminal pay were not included in compensation earnable as a result of the changes made by AB 340 and AB 197. Employees, of course, argued that the change made by the retirement boards infringed a vested right, that it was not permissible. And what's really interesting about the decision is that it includes very broad policy discussions about why it is important for a legislative body to have flexibility to change benefits. And it says, look, if we don't allow local governments to make changes to underlying benefits to be consistent with or to respond to changing economic conditions, we're robbing them of their necessity or the ability to really adapt and be able to function and provide what they need. And while you can't make these wholesale unreasonable changes, there should be that flexibility to allow for those changes to be made. What was also relevant about this decision was that the court indicated, again, responding to or reiterating the earlier Supreme Court holding in Kern, that employees didn't have a right to a fixed pension benefit, that they had a right to a substantial and reasonable pension, and that importantly, that a modification to benefits didn't need to be accompanied by a comparable benefit. The court was responding to earlier decisions by courts that had suggested that the comparable benefit had to be offered in exchange to the elimination of a benefit. And so the idea then was, well, if we have to offer a comparable benefit by removing a benefit, then we're not really achieving savings. And so this court clarified that in its view, it was clear that it was a permissive provision, not a mandatory requirement. The case is currently before the California Supreme Court. The court agreed to hear the case, but it's on hold pending resolution of the Alameda case, which I will refer to in just a few minutes. CAL FIRE is another case that is currently before the Supreme Court. It is actually has been fully briefed and is expected to be heard by the Supreme Court sooner than the Marin or Alameda cases. This one revolves around the elimination of airtime that was imposed under the provisions of PEPRA, pension reform. And airtime is the ability of employees to purchase up to 5 years of time without it being associated with actual work time. And so what PEPRA did is it eliminated that option for all employees, not just new members to the system, but all, including classic or legacy members, and so they could no longer purchase airtime. As you can imagine, classic members, those who were not subject to pension reform, generally challenged the elimination of that benefit, and the court said, no, you don't have a vested right to this benefit. There's no indication that the Public Employees Retirement Law, which was the basis of challenging this, intended to create a vested right in airtime, and so therefore the legislature was entirely, did not impair a vested right by eliminating that benefit. The court borrowed heavily from the retirement health benefit cases of the Supreme Court in the Orange County situation, and said that the employees had a very heavy burden to establish or overcome this idea that there was a vested right. They needed to establish that the intent had been to create a vested right, and again, the court held that they failed to do so. So the CAL FIRE case was, earlier court decided after the Barron case, and it referred very favorably to the Barron decision. And so the idea was that once the Supreme Court heard the Barron case, there was this expectation that perhaps there would be some movement in the way the California rule is interpreted. As I said, the California Supreme Court agreed to hear the case. It has been fully briefed. There have been multiple briefs submitted in favor of the government's position, and Governor Brown himself has taken the lead in defending PEPRA. Alameda County, again, is based on a modification made to the underlying benefits of a county employee's retirement system. Similar types of benefits that have been previously included because of the Ventura decision earlier in the 90s were deemed to be impermissible by the retirement board because they essentially resulted in spiking compensation, which was one of the goals of the amendments made by pension reform to eliminate this enhancement or impermissible enhancement of retirement benefits. It involved employee associations from multiple counties, Alameda, Contra Costa, and Merced. And again, the plaintiffs argued that they had a vested right to the continued inclusion of those benefits. The trial court agreed with the retirement boards and said that the retirement boards had rightfully properly acted in accordance with underlying changes to the law made by the legislature. And when it went to the appeal court actually took a more nuanced view of it. It looked at the changes that the retirement board had made, which included eliminating terminal pay, so pay received after separation, eliminating cash outs not earned in the year that they were reported, and on-call payments as well. And it looked at it separately, and it made several holdings. First, it said that with respect to terminal pay and pay that was earned in periods not related to the final compensation period, that those were just a reflection of existing law. And so therefore, you could not impair a benefit if it wasn't allowed under underlying law. So it agreed with the trial court. But with respect to on-call pay that was earned in connection to normal pay, the court said, no, this was actually a vested right. And whether or not this could be changed depended on whether the change resulted in a substantial impairment. The court diverged from the Marin court in that it said that it was not persuaded that the Marin court engaged in a very detailed analysis of vested rights obligations, and so felt that it could not follow that case. And so it, contrary to Marin, where Marin said, look, if the benefit is small enough, and it's not really an impairment of vested rights, so it's permissible, this court said the benefit has to be substantial enough to show a real change in the fiscal stability of the system. And if it's not significant, then there is no real authority. It's an impairment of a vested right to eliminate or impair that benefit. So Alameda, in a lot of ways, challenges the Marin Court decision, and it will be very interesting to see how the Supreme Court rules in that respect. And so it brings up this idea of whether or not we expect there to be significant movement in the Supreme Court's decision once it hears both the Marin and Alameda cases. And there's significant arguments both in favor and against. And one of the more prevailing arguments in favor of a substantial change to the California rule is this idea that public employees should not expect to get a more generous benefit than private sector employees. That under ERISA, you only have a right to what you've accrued to date. You don't have a vested right to future accruals. And so public employees should get the same entitlement. But of course, the argument against that is the fact that employees, when they take employment with a public agency, do so with the expectation of a pension benefit that they will get upon retirement. So there's this idea that but for this incentive, they would not have accepted this employment benefit. And because of the contract clauses that public agencies are subject to under the Constitution of the U.S. and California, that there might be a certainly higher standard and expectation with respect to those benefits. And then finally, implications. If there is a change, what does that mean? Well, it means that there might be more flexibility as to what you can offer both current and future employees. Now, with those agencies that are still or are part of CalPERS, a change in the California rule is not enough, as you know. There's changes that need to happen to PERL, to the Public Employees Retirement Law, to allow changes related to the California rule to be implemented if, in fact, there's changes or modifications to those rules. So, for example, in CalPERS, if you're in for all of your employees, even your new employees. Whereas under the California rule, even without any changes to it, new employees are not subject to or do not have a vested right, and so you can offer them a different set of benefits. But again, if you're in CalPERS, you can't do that. So any change in the California rule is going to have to be accompanied by a change to the Public Employees Retirement Law as well. So a lot to fit in just 15 minutes, as I said, just the start of the conversation. I have confirmed with our marketing department that articles that I've done on both the Marin and Alameda cases in detail will be available as a link. So if you want to learn more about these cases, you can certainly do that. And I will be available at any time to answer any questions. Thank you.